Anyone who's ever performed the role often will remark they had no idea what was all involved, and maybe they'd never like to take it on again. But it's an education.
Welcome, Margaret, to the Steadyhand Coffee Break video series. Thanks ever so much for joining us.
Well, thank you, David, for giving me the opportunity to join you today.
Well, super excited to have you on our Coffee Break series to talk about estate planning, and specifically about the roles and responsibilities of your estate executor. That's the person that you have to choose to ensure that your wishes are carried out after your passing. So, Margaret, you deal with this on a daily basis. Can you start off by explaining the key responsibilities of an executor?
Well, there are quite a few of them, and some people might be surprised to find that the role is really quite onerous. But let's go through a little bit of a laundry list of what the key duties are. And right from the get-go, well, the first obligation of the executor is to arrange the funeral, the cremation, the burial, and look after all of those arrangements. That, under law, that's the responsibility of the executor named under the will. Now, of course, they will liaise with the family, but ultimately, they're the ones who have the responsibility. They sign, for example, the contract for the funeral services. They're responsible for making sure everything is carried out in an efficient way and cost effectively. That's number one. From there, we're now getting really into administering the estate. Well, the first thing to figure out are what are the assets of the estate? As well, what are the liabilities of the estate? And to create essentially an inventory. And that's going to be really the key document in terms of figuring out what needs to be done. And often from there, that will look at creating an actual action plan to figure out what next steps have to be taken. Employing professionals. So typically, you're going to need a lawyer, often in order to make a court application to probate the will. Typically, you'll need an accountant to look after all of the tax compliance, and other professionals potentially as well, maybe a real estate agent if a property is to be sold, or an investment manager. So a lot of other professionals that ultimately will get involved, but the executor will be the fiduciary who's charged with essentially retaining those individuals and ensuring that they carry out their roles effectively and cost effectively. So that's another role. Keeping records. So at the end of the day, the executor has a duty to account back to the beneficiaries. So they really need to ensure that they keep great records, because they really do need to be able to say where every single penny went, what came in, when one went, what went out. So that's quite important. They'll be involved in liquidating assets of the estate if, in fact, they already be liquidated. Not always. Sometimes some assets are passed out, what we call in specie, in kind. But for the most part, a lot of the assets will be liquidated, investments sold, and cash distributed, because that's usually what the most simple things are. Tax compliance. Our Income Tax Act visits a very strong liability on the executor to perform all the compliance necessary. And if they don't, or do it incorrectly, or they're late in filing, they can be essentially personally liable for penalties and for income tax liability. And if they distribute the estate without getting a proper clearance certificate from Canada Revenue Agency, they can actually be liable for any unpaid tax. So that's something certainly to be aware of. So those are some of the key roles in terms of the administration, but then, of course, carrying out the terms of the will. Looking exactly what the will says you're supposed to do, whether it's a cash legacy, distributing a particular personal effect, and then figuring out what amounts are to be paid to the beneficiaries. Usually there's a residue clause, which picks up everything that's left after you've paid all the bills and the debts and the expenses and the taxes and distributed out cash to any legatees or personal effects, dividing up the residue and making a distribution to the beneficiaries. Need to identify all the beneficiaries. So that's a key part too. And in terms of just the overriding legal obligations, well, executors really, they can't just hand over to anyone this role. They're not supposed to delegate any key decision making. They are supposed to make the decisions themselves, make sure that they don't have any kind of a conflict of interest in terms of what they're doing. So that's something to avoid. For example, purchasing an asset from the estate. Well, that's generally not allowed unless you've got permission of all of the beneficiaries or a court order. So essentially avoiding any of those kinds of conflicts, making sure that you're fair, even-handed in terms of how you treat beneficiaries, that there's good communication, of course, keeping accounts, as I mentioned to you. So those are some of the key duties of the executor, what the role is. So I think you can see that it's not straightforward, and anyone who's ever performed the role often will remark they had no idea what was all involved, and maybe they'd never like to take it on again. But it's an education.
Thank you for taking us through that. I have a sneaky suspicion that anybody watching this is definitely going to think twice about saying yes. And is it possible for us to post to the video notes below that list that you just went through? Is that a document that you have?
I could actually provide you with a written list, which goes through the whole thing from A to Z.
That'd be great. Now, Margaret, as we just went through, there's a lot going on there. When do you think is the best time as you're planning your estate to actually choose your executor and reach out and get that person to agree to do that job?
Well, when we're doing the planning, the whole issue of who should be the executors is often a pretty fulsome discussion. And what's essential is to make sure that they will take on the role, that they're willing and able. No point just putting somebody into your will and then finding out that actually they're not really interested in taking on the role or can't for whatever reason. So it is important to, I think, have a discussion with your intended executors. Maybe not necessarily the people that are what we call the contingent ones, who will only act if the primary ones cannot, but at least the primary executors have a good discussion and make sure that they're willing to take on the role. So that's essential.
And as you go through your work with your clients, thinking about their choice of executor, what are the essential traits or characteristics that you think should be prioritized when choosing your executor or executors?
Well, when you talk about traits, I'm going to talk a little bit about personality, I think, which is a little different than perhaps other issues like tax issues and where they reside. But let's actually look to the core of who the person is, and being very fundamental to being an executor. You have to be fair, you have to be impartial, and you have to be trustworthy. So essentially, who you entrust your estate to has got to be someone you really have ultimate faith and confidence in terms of their integrity, in terms of those issues that I mentioned of trustworthiness and fairness and impartiality. So those aren't things you can just easily buy. Somebody told me you can buy a lot of other things. You can buy professional acumen and skills and that kind of thing, but buying trust, no, you earn somebody's trust, and it's got to be essentially someone that you have that confidence in.
Now, you can buy the executor services from a third party. So there's two possibilities. You can hire a trust company, I guess, or you can appoint a family member or a family friend or something like that. So how do you guide your clients in thinking about this decision? Like, what are the advantages and disadvantages of each option?
Well, it really comes down to looking at what are we going to administer and who are the family members and beneficiaries. What are some of the family dynamics? So there's quite a combination of issues in terms of figuring out what do we need here? What's going to be the best combination if we have more than one? Or do we need even more than one? We have one beneficiary who's absolutely capable to administer the estate, then probably we don't need anyone else. They essentially are doing it for themselves. Okay, so we don't really need to have likely more than one. But many situations we do, because we're actually administering an estate for a group of beneficiaries. Much will depend on who they are. So let's take the example of we've got 3 minor children. They're all under the age of 18. Well, I'm kind of look at what is the best combination. I would say you'd probably want more than one. Why? Because you want to have a balance and a check. You're administering assets often for the long term, could be 2 or 3 decades before those children that are children today reach the ages that they're entitled to receive their inheritance. So we've got a long-term role. We want to have accountability. We want to have transparency. We want to have more than one person, not just one person writing checks, but for all the good reasons why if you were running a company, you don't put all your eggs in one basket. We want to diversify and have a balance and check in terms of handling a lot of money. But as well, we want to make sure there's continuity. So you have one person, something happens to them, well, there's a problem. There's no continuity for a while until you figure out who the new person will be. So making sure there's a team, having more than one, provides, I think, a lot more comfort in terms of the role. But as well, you're probably going to want to match a number of different skills and also relationships. So perhaps one of the executor team will be someone who's very proficient in, generally a lot of business acumen, oversight, making sure that things are invested correctly, the tax compliance is done, is good at managing those kinds of duties. There could be another executor, though, that you want to make sure that the children somehow have someone who can speak for them, knows what their needs are, can communicate that to the executor, other executors. So there could be a role for a family member. So putting all these things together, we can create a team. And that's, I think, what we're trying to do. Also, people, you've got to look at, well, yes, you can have, they all look good on paper, but maybe they don't work well together. So got to ensure that by asking all the right questions of the people making the appointment, that they're confident that people will, for the most part, get along together, will be able to work together, that there's not going to be dissension. And when we have multiple executors, often we do solve some of the problems by making sure we have more than two. Because if there's only two and they don't get along, we have what we call deadlock. And ultimately, that might lead to one person having to resign or be removed by the court, and then we're into litigation. So having three or an odd number, we can have a majority rule clause, which would allow two of three to make a decision. So hopefully using that kind of a mechanism, we can still move along with the estate administration.
Well, that all makes sense. So you're sort of balancing the team, both in terms of conflict management, diversification of skills, and then just sort of diversifying the roles and responsibilities to be fair, not laying it all on one or potentially two individuals. Now, are there any technical considerations related to either the executor's age or their physical location, like where they live, that need to be taken into account?
Well, certainly with regard to the latter. Now, the former, really no, except that they need to be 18 years of age. They have to be age of majority to be an executor. There's no upper limit in terms of age, but it could be built in to the terms of the will, in terms of a particular age at which the executor is to resign. Don't see it very typically, but it probably is often a good idea, because sometimes we do see this role being carried out by people who are really not at that point really able to carry it out effectively. But apart from that, there aren't any restrictions, nor on number. But in terms of where they live, yes, there can be issues, both legal and tax, with regard to the choice of executors. So under our Income Tax Act and essentially case law, which has developed in terms of where you consider an estate to be resident, is the test is really now through case law, some of it not very old, but about 10 years ago, a leading case called Garone, but it's where the mind and management of the estate is, which typically will mean where a majority of the executors reside, but it's not a hard and fast rule with regard to residence. The mind and management rule will take into account a number of factors, but essentially really where the place is, where the decisions are being made, the professional advisors are located, the records are kept, that type of thing. Meetings are held. So typically we're going to want to make sure if we have a Canadian resident, that we have a Canadian resident estate, and we don't, because of the choice of executors, end up in some other jurisdiction and subject to their tax laws. So we'll be looking at least at the beginning of having the estate in Canada. We typically will want to ensure that the executors, or at least a majority of them, are Canadian residents. So that's one issue. That's a tax issue. There can be some other issues as well, legal issues. So if we have an executor who's not a resident of a Canadian province or territory, or of a member of the British Commonwealth, that executor is typically, at least in Ontario, under our rules, required to post a bond or have a surety. So that's a complication and an expense. So the bond issue can be an issue. Another issue that has become more relevant in the last few years is really an issue involving if we have a U.S. resident executor or an attorney for property being named, and if there's an investment account with a Canadian financial institution who is providing investment advice, will they be able to continue to provide advice to that non-resident executor? And in many institutions, they're not, because they're not licensed to do that under the U.S. Securities Act. So that can be a bit of an issue too. Now, there are workarounds to all of these things, but with proper advice, we can often achieve the objective that we would like, but essentially does require considering all those issues. So it's not that straightforward.
Well, we could have a whole nother video, and maybe we will have a whole nother video advising the appointees on how they can make life easier for the appointer, on how they can make life easier for the appointee. But let's sort of wrap up by considering the perspective of the appointee, the executor who's been named in the will. Hopefully they've been made aware that they've been named in the will before the person dies, but what should they be asking themselves and the person that's appointed them before actually accepting this responsibility? And do you actually have to accept this responsibility, or can it just be assumed?
Well, that's a great question. No, you don't have to accept the responsibility. But if you're not going to accept the responsibility, you really should do it right at the beginning. Because once you start to do things, our law will basically say you have intermeddled in the estate and there can be some liability issues. But you don't have to take on the role. You can renounce your right to be the executor. And that's something people should bear in mind. What should you find out about the estate? I think generally people should find out a little bit about any issues that they should know about in terms of, is there any kind of things that could cause a problem? There should be some fairly good disclosure if there are. But if it's essentially kind of a normal sort of plain vanilla situation, I just want to know generally what kind of assets there are and family relationships. There could be a very complex estate, maybe with a business. Well, that's a whole other thing. I think that you're really then going to have to sit down, the person drawing the will, with the people that they're going to be naming as their executors, to give them quite a bit of information about what it's going to be all about so that they're prepared to take on the role.
And finally, Margaret, how do you know when your job as executor is complete? And then are you somehow released?
You are. You are. So essentially, the process will be throughout the administration, and when distributions are made, typically to get a release for that period up to that distribution, and then another one if there's a second distribution, and then a third when there's a final distribution, so that the entire estate is approved and the executors are released in terms of any claims that might be asserted by the beneficiary, and as well, typically often an indemnity with regard to taxes and liabilities in case something were to come up in future, because now the beneficiaries have the money and the executor does not, in terms of indemnifying the executor against those kinds of claims. And the final sort of step often is, in many cases, getting a clearance certificate from Canada Revenue Agency, which essentially absolves the executor in terms of if, in fact, after that clearance certificate, now all returns are being assessed, there should be discovered a tax liability or something of that nature. Something came up, another asset, whatever. The trustee is no longer responsible in terms of being legally liable for those unpaid taxes.
Well, Margaret, lots and lots to think about. Thank you so much for bringing your expertise to this topic. We'll link to your website, and I know that people will want to go there and sign up for your newsletter. And we'll have some of the other documentation that we referred to earlier available in the video notes below. Everybody, thank you for watching. Be sure to let us know any thoughts or feedback that you have, or any questions that you might want to have addressed in the comments below. And if you're not yet subscribed to the Steadyhand YouTube channel, we would encourage subscribing so you can be notified of new videos as soon as they're released. Again, Margaret, thank you. And thank you all for watching, and bye for now.
Thank you.